in the copy of the General Theory of Law and Marxism by Pashukanis that I have, there are a couple of different prefaces that start before the actual essay begins. So I'm just going to read these prefaces. They're short, so I'm just going to read them all together, so I don't have to make a video for each individual one. So anyway, here we go. Preface to the German edition. In bourgeois society, jurisprudence has always held a special privileged place. Not only is it first among the other social sciences, but it also leaves its mark on them. Not for nothing did Engels call the juridical way of looking at things the classical worldview of the bourgeoisie, a kind of, quote, secularization of the theological, end quote, in which, quote, human justice takes the place of dogma and divine right, and the state takes the place of the church, end quote. By destroying the bourgeois state and overturning property relations, the proletarian revolution created the possibility of liberation from the fetters of legal ideology. Quote, the workers lack property, end quote, wrote Engels in the piece quoted from above. The workers' lack of property, wrote Engels in the piece quoted from above, quote, was Jesus Christ. The workers' lack of property, wrote Engels in the piece quoted from above, quote, was matched only by their lack of illusions, end quote. But the experiences of the October Revolution have shown that even after the foundations of the old legal order have collapsed, after the old laws, statutes, and regulations have been transformed into a heap of waste paper, old mental habits still exhibit an extraordinary tenacity. Even now, the struggle against the bourgeois legal view of the world represents a task of pressing importance for the jurists of the Soviet Republic today. Whilst in the sphere of the theory of the state, Lenin's State and Revolution, published as early as November 1917, already gave a consistent and consummate Marxist view, the critical work of Marxist thought in the sphere of the theory of law began much later. Immediately following the October Revolution, we encounter an attempt to call upon the completely and utterly un-Marxist, typically petty bourgeois psychological theory of law as a rationalization for the immediate destruction of the old machinery of justice. The revolutionary measure, not in dispute as a political measure, of destroying the old courts constituted by the Tsarist and Kerensky regimes, the creation of new people's courts not bound by the norms which the October Revolution had smashed, was interpreted from the point of view of a theory which regards law as the sum of psychological, quote, imperative attributive experiences, end quote. Subsequent attempts to give this theory some substance led its adherents, in particular Reisner, who died recently, to assert that there were different systems of intuitive law existing side by side simultaneously within the borders of the USSR, a proletarian, a peasant, and a bourgeois system. Official Soviet law was depicted as a compromise between these systems, a kind of mixture containing all three elements. It is quite obvious that this standpoint reduces the significance of the October Revolution as a proletarian revolution to nothing and eliminates any possibility of producing an integrated evaluation of Soviet law, or of determining the criteria for such an evaluation from the point of view of its sustainability or Jesus Christ. Man, I got fucking dyslexia today. It's quite obvious that this standpoint reduces the significance of the October Revolution as a proletarian revolution to nothing and eliminates any possibility of producing an integrated evaluation of Soviet law or of determining the criteria for such an evaluation from the point of view of its suitability or unsuitability for the way forward to socialism. The anti-individualistic theories of those Western European jurists who represent the so-called, quote, socio-economic view of law were no less influential than the psychological theory for juridical thought in the Soviet Union. In their constructions, these jurists, Duguay, Hedemann, and others, reflect modern capitalism's rejection of the principle of free competition and thus of the principle of unlimited individualism and formalism. Their theories are undoubtedly interesting and could be made the most of in the struggle for socialist planning against bourgeois capitalist anarchy, but they can in no way provide a substitute for a revolutionary dialectical approach to questions of the law. The task of the Marxist critique was not confined to refuting the bourgeois individualistic legal theory of law. The task of the Marxist critique was not confined to refuting the bourgeois individualistic theory of law, but also consisted of analyzing the legal form itself, exposing the legal form's sociological roots, and demonstrating the relative and historically limited nature of the fundamental juridical concepts. At the same time, there was a need to raise one's voice against any attempt to blur over the fundamental contradiction between capitalism and socialism, to veil, with the help of cleverly devised, quote, transformations of civil law, end quote, the class nature of capitalist private property, and to attach the label of, quote, social function to it. The Soviet state does not admit any absolute and untouchable subjective private rights, but it counterposes to this fetish neither some classless principle of social solidarity nor the bare idea of developing the productive forces, but the concrete task of constructing socialist society and destroying the last vestiges of capitalism. This task of elaborating a revolutionary dialectical and materialist method of jurisprudence, as opposed to the metaphysical, formal, logical, or at best historical evolutionist method of bourgeois jurisprudence, has been taken on by the section of politics and jurisprudence of the Communist Academy. The present work, which is recommended to the attention of the German reader, is a modest contribution towards accomplishing this task. Pashukanis, May 1929. Preface to the third Russian edition. There are no substantive changes in this third edition of the work as compared with the second. Naturally, the reason for this is not that I had nothing to add to what I had already said, or felt that further elaboration and partial revision were superfluous and impossible. On the contrary, the time has now come when the ideas which were only briefly sketched in this work can and should be set out more systematically, more concretely, and more fully. The last few years have not left the Marxist theory of law untouched. At this point in time, there is already sufficient material for each separate legal discipline. Many individual problems have already been subjected to discussion. A foundation, albeit only a provisional one, has been laid, upon which one could base a draft Marxist guide to the general theory of law. It is precisely because I have set myself the task of writing such a text in the very near future that I have decided against any further changes in the work to hand. It is preferable that this sketch remain what it was, a first draft of a Marxist critique of the fundamental juridical concepts. Those footnotes which appear in this edition are for the first time are indicated as such. Pashukanis, July 1927. Preface to the second Russian edition. When I submitted my work to the public, nothing was further from my mind than that there would be a need for a second edition, and in a relatively short time at that. Moreover, I am convinced that this came about only because the work, which was meant to provide at best a stimulus and material for further discussion, was put to a use which the author had not envisaged at all, that is, as teaching material. This fact in turn can be explained by the circumstance that there is very little Marxist literature on the general theory of law. How should this be otherwise, when there was doubt in Marxist circles until very recently as to whether there was such a thing as a general theory of law? Be that as it may, the work to hand lays no claim whatsoever to the honorary title of a Marxist textbook on the general theory of law, in the first place for the simple reason that it was largely written for the clarification of the author's own ideas. This is the reason for its abstract nature and for the compressed form of presentation, which has the air of a first draft in places. This also explains its one-sidedness, which is unavoidable when one concentrates one's attention on particular aspects of the problem which appear to be crucial. All these characteristics make the work fairly unsuitable for use as a textbook. Nonetheless, although I am well aware of these shortcomings, I have still decided against eliminating them. The following considerations led me to make this decision. The Marxist critique of the general theory of law is still in its early stages. Definitive conclusions will not materialize overnight. They will have to be based on rigorous elaboration of every single branch of jurisprudence. However, there is still much to be done in this respect. I will no doubt suffice to point out that the Marxist critique has not even touched on such fields as that of international law as yet. The same goes for judicial procedure and, though to a lesser extent, for criminal law. In the field of the history of law, all we have is what the general Marxist theory of history has to offer on the subject. Only constitutional law and civil law in some measure represent welcome exceptions. Hence, Marxism is just beginning to conquer new territory. It is natural that this should occur at first in the form of discussion and of conflict between differing viewpoints. My work, which raises some questions of the general theory of law for discussion, serves principally to prepare the ground in this way. That is why I have elected to preserve its original character in the main and have not tried to adapt it. One second. Sorry, I gotta repeat that. That is why I have elected to preserve its original character in the main and have not tried to adapt it to the requirements to which any textbook would have to conform. All I have done is to make those additions which were necessary, occasioned in part by suggestions made in the reviews. I think it will be useful to make at the outset some prefatory remarks about the fundamental ideas of my work. Comrade Stuchka has quite correctly defined my approach to the general theory of law as a, quote, attempt to approximate the legal form to the commodity form, end quote. As far as I could make out from the reviews, this idea was acknowledged on the whole, despite individual reservations, as successful and fruitful. That can, of course, be explained by the fact that I did not, after all, have to, quote, discover America in this matter. There are enough elements of such an approximation in Marxist literature, above all in Marx himself. It will suffice for me to refer, in addition to the quotations from Marx cited in the work, to the chapter, quote, Morality and Law, Equality, end quote, in the Anti-During. In it, Engels gives an absolutely precise formulation of the link between the principle of equality and the law of value, with the footnote that, quote, this derivation of the modern idea of equality from the economic condition of bourgeois society was first expounded by Marx in Capital, end quote. What remained, therefore, was to fuse the individual ideas thrown up by Marx and Engels into a unity and to attempt to think through some of the conclusions arising from this. The task consisted of this alone. The basic thesis, namely that the legal subject of juridical theories is very closely related to the commodity owner, did not, after Marx, require any further substantiation. Similarly, the next conclusion, too, contained nothing new. Its import is that the philosophy of law, based on the category of the subject, with his capacity for self-determination, for bourgeois scholarship has not as yet created any other consistent system of legal philosophy, is actually basically the philosophy of an economy based on the commodity, which specifies the most universal abstract conditions under which both exchange can take place according to the law of value and exploitation can occur in the form of the, quote, free contract, end quote. This view is the basis for the critique by communists of the bourgeois ideology of freedom and equality and of bourgeois formal democracy, that democracy in which the, quote, republic of the market, end quote, masks the, quote, despotism of the factory, end quote. This view leads us to the conviction that defense of the so-called abstract foundations of the legal system is the most general form of defense of bourgeois class interest and so forth. If, however, the Marxian analysis of the commodity form and the closely related form of the subject has been most widely applied as a weapon in the critique of bourgeois legal ideology, it has not been made use of at all in studying the legal superstructure as an objective phenomenon. This was prevented, above all, by the circumstance that the few Marxists who concerned themselves with legal questions undoubtedly considered the aspect of social, state coercive regulation as the central, fundamental, and only characteristic trait of legal phenomenon. It seemed as though this viewpoint alone vouchsafed the scientific, that is to say, the sociological and historical approach to the problem of law, in contrast to the ideological, purely speculative systems of legal philosophy based on the concept of the subject with its capacity for self-determination. Hence, it was quite natural to think that the Marxian critique of the legal subject, which arises directly from analysis of the commodity form, had nothing to do with the general theory of law, since, of course, external coercive regulation of the relations between commodity owners forms only an insignificant part of the social regulation as a whole. In other words, from this point of view, it seemed that everything which could be learnt from Marx's conception of the, quote, guardian of commodities, end quote, whose, quote, will resides in those objects, end quote, could be applied only to a relatively narrow sphere of bourgeois society's so-called law-governing intercourse, but was totally inapplicable to the remaining branches of law, constitutional law, criminal law, and so on, and to other historical formations such as slavery, feudalism, and so on. That is to say that on the one hand, the significance of Marxian analysis was limited to a particular sphere of law, and that on the other hand, its findings were used only to expose the bourgeois ideology of freedom and equality, only in the critique of formal democracy, but not to throw light on the fundamental characteristics of the legal superstructure as an objective phenomenon. In the process, people failed to take two things into account. First, that the principle of legal subjectivity, which we take to mean the formal principle of freedom and equality, the autonomy of the personality, and so forth, is not only an instrument of deceit and a product of the hypocrisy of the bourgeoisie, insofar as it is used to counter the proletarian struggle to abolish classes, but is at the same time a concretely effective principle which is embodied in bourgeois society from the moment it emerges from and destroys feudal patriarchal society. Secondly, they fail to take into account that the victory of this principle is not only and not so much an ideological process, that is to say, a process belonging entirely to the history of ideas, persuasions, and so on, but rather is an actual process, making human relations into legal relations, which accompanies the development of the economy based on the commodity and on money. In Europe, this means capitalist economy, which is associated with profound universal changes of an objective kind. These changes include the emergence and consolidation of private property, its universal expansion to every kind of object possible, as well as to subjects, the liberation of land and the soil from the relations of dominance and subservience, the transformation of all property into movable property, the development and dominance of relations of liability, and finally, the precipitation of a political authority as a separate power, functioning alongside the purely economic power of money, and the resulting more or less sharp differentiation between the spheres of public and private relations, public and private law. Thus, if analysis of the commodity form reveals the concrete historical significance of the category of the subject in the basis of the abstract schema of legal ideology, then the historical process of development of the economy based on the commodity and on money and on capitalist commodity production goes hand in hand with these schema, materializing in the concrete form of the legal superstructure. The conditions for the development of a legal superstructure with its formal statutes, courts, trials, lawyers, and so forth are present to the same degree that human relations are constructed as relations between subjects. It follows from this that the basic traits of bourgeois civil law are simultaneously also the characteristic traits of the legal superstructure as such. If at earlier stages of development, equivalent exchange in the form of indemnification and compensation for damage done produced that most primitive legal form which we find in the so-called legis of the barbarians, then in future, the vestiges of equivalent exchange in the sphere of distribution, which will be retained even in a socialist organization of production until the transition to developed communism, will compel socialist society to enclose itself within the, quote, narrow horizon of bourgeois law, end quote, for a time, as Marx himself foresaw. The development of the legal form, which reaches its peak in bourgeois capitalist society, takes place between these two extremes. One can also characterize this process as the disintegration of organic patriarchal relations and their replacement by legal relations, that is to say, by relations between formally equal subjects. The dissolution of the patriarchal family, in which the paterfamilias was the owner of his wife's and children's labor power, and its transformation into a contractual family in which the spouses conclude between themselves a contract of their estate, and the children, as is the case, for example, on the American farm, receive wages from the father, is one of the most typical examples of this development. The development of relations based on the commodity and on money carries this evolution still further. The sphere of circulation, which is expressed in the formula commodities sold for money, which purchase other commodities, plays a leading part in this. Commercial law fulfills the same function in relation to civil law as civil law does with regard to all remaining branches of law. This is to say that it points in the direction of development. Thus, commercial law is on the one hand a particular province. One moment. Thus, commercial law is on the one hand a particular province of importance only to those people who trade it, whose trade. Thus, commercial law is on the one hand a particular province of importance only to those people whose trade it is to transform the commodity into money form, and vice versa. Yet, on the other hand, it is civil law itself, in its dynamics and in its movement towards those purest models from which every trace of the organic has been eradicated. Models in which the legal subject appears in its consummate form as the indispensable and unavoidable complement of the commodity. Thus, the principle of legal subjectivity and the model it implies, which appears to bourgeois jurisprudence as the a priori model of the human will, follows with absolute inevitability from the conditions of the economy based on the commodity and on money. The strictly empirical and technical conception of the connection between these two aspects is expressed in observations to the effect that the development of trade fosters security for property, good law courts, a good police force, and other such things. But if one looks into it in greater depth, it then becomes clear not only that one or other technical arrangement of the machinery of state is based on the market, but also that there is an indissoluble internal connection between the categories of the economy based on the commodity and on money and the legal form itself. In a society where there is money, and hence individual private labor becomes social labor only through the mediation of a universal equivalent, the conditions for such a legal form with its antitheses between the subjective and the objective, between the private and the public, are already given. Only in a society of this kind does political power have the possibility of setting itself up in opposition to purely economic power, whose most pronounced manifestation is the power of money. Simultaneously with this, the statute form also becomes possible. It is therefore unnecessary for the analysis of the fundamental definitions of law to start out from the concept of the statute and to use it as a guide, since this concept is itself, of course, as an order emanating from the political power, an appurtenance of a stage of development at which the division of society into the civil and the political has already occurred and become stabilized, and at which, accordingly, the fundamental aspects of the legal form have already come into being. Marx says that, quote, the establishment of the political state and the dissolution of civil society into independent individuals, whose relations with one another depend on law, just as the relations of men in the system of estates and guilds depended on privilege, is accomplished by one and the same act, end quote. Of course, it in no way follows from what has been cited above that I regard the legal form as a, quote, mere reflection of purist ideology, end quote. I think I have expressed myself quite clearly on this issue. Quote, law as a form does not exist in the heads and the theories of learned jurists alone. Law as a form has a parallel real history which unfolds not as a set of ideas but as a specific set of relations, end quote. At another point I speak of the juridical concepts which, quote, comprise a theoretical reflection of the legal system as a system of relations, end quote. Put another way, the legal form expressed in logical abstractions is a product of the actual or concrete legal form, to use Comrade Stuchka's expression of actual mediation by the relations of production. Not only did I point out that the genesis of the legal form should be sought in the relations of exchange, but I also stressed the aspect which in my view represents the most consummate manifestation of the legal form, the law court and the juridical process. It goes without saying that in the development of any one legal relation there are differing more or less pronounced ideological conceptions in the mind of those involved about themselves as subjects, their own rights and obligations, their own, quote, freedom of action, the limitations of the law, and so on. However, the practical significance of legal relations certainly does not lie in these subjective states of consciousness so long as the commodity owner is only aware of himself as a commodity owner. He has not yet mediated the economic relation of exchange with all its further consequences, which escape his consciousness and his will. Legal mediation is accomplished only in the instant of the contract, but a concluded business agreement is no longer merely a psychological phenomenon. A concluded business agreement is neither a, quote, idea nor a, quote, form of consciousness. A concluded business agreement is an objective economic fact, an economic relation which is inextricably linked to its similarly objective legal form. The more or less unfettered process of social production and reproduction formally carried out in commodity-producing society through individual private legal transactions is the practical purpose of legal mediation. This purpose cannot be achieved with the help of forms of consciousness alone, that is to say, through purely subjective aspects. It requires exact criteria, statutes, interpretation of the statute, casuistry, law courts, and the compulsory execution of court decisions. For this reason alone, one cannot limit oneself when analyzing the legal form to, quote, pure ideology, end quote, nor can one disregard the whole of this objectively existing machinery. Every legal action, for example, the outcome of a lawsuit, is an objective fact which has its place outside the consciousness of the parties to it, in just the same way as the economic phenomenon which it mediates. Another of the things with which Comrade Stutzka reproaches me, namely that I recognize the existence of law only in bourgeois society, I grant with certain reservations. I have indeed maintained and still do maintain that the relations between commodity producers generate the most highly developed, most universal, and most consummate legal mediation, and hence that every general theory of law and every, quote, pure jurisprudence, end quote, is a one-sided description, abstracted from all other conditions, of the relations between people who appear in the market as commodity owners. But a developed and consummate form does not, of course, exclude undeveloped and rudimentary forms. Rather, to the contrary, it presupposes them. Presupposes the undeveloped and rudimentary forms. This is the way it is, for instance, with private property. Only the aspect of free alienation fully reveals the fundamental nature of this institution, although property as appropriation undoubtedly existed earlier than, not just the developed form, but also the most embryonic forms of exchange. Property as appropriation is the natural consequence of every mode of production, but only within a particular social formation does property take on its logically simplest and most universal form as private property, determined by the simple precondition of the uninterrupted circulation of value according to the formula, commodity, money, commodity. Exactly the same is true of the relation of exploitation. This relation is, of course, in no way bound to the exchange relation and is conceivable in a natural economy as well, but only in bourgeois capitalist society where the proletarian figures as a subject disposing of his labor power as a commodity is the economic relation of exploitation mediated legally in the form of a contract. This is linked precisely with the fact that in bourgeois society, in contrast to societies based on slavery or serfdom, the legal form attains universal significance. Legal ideology becomes the ideology par excellence, and defending the class interests of the exploiters appears with ever-increasing success as the defense of the abstract principle of legal subjectivity. In a word, the purport of my analysis was not at all to deny the Marxist theory of law access to those historical periods which were as yet unfamiliar with developed capitalist commodity production. On the contrary, I was and still am concerned to facilitate understanding of the embryonic forms we find in those epochs and link those embryonic forms in those epochs to the more developed forms through a general line of development. The future will tell the extent to which my approach has been fruitful. Obviously, I could only sketch the basic traits of the historical and dialectical development of the legal form in my short outline. In the process, I made use in the main of ideas I found in Marx. It was not my task to solve all or even only a few of the problems of the theory of law. I merely wished to show how one could approach them and how the questions should be put. I am gratified by the fact alone that some Marxists found my approach to questions of law interesting and not without prospects. This further strengthens my desire to extend my work in the same direction.